And Judge, my client will need an interpreter,
Who's your client?
Mr. Delgado.
Is the interpreter here? I know we requested one.
Not yet, Judge, but I will follow up.
Okay, so let's go to whoever we're going to get started. Good afternoon. This is Judge Elisa Perez, presiding over the 210 District Court criminal docket for the 21st of March, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, will you call our next case, please?
Bottom of page 21. Annex, may we have David Aguilar?
Yes, sir. It's on the run.
Good afternoon, Your Honor.
Good afternoon, Ms. Nava.
So, we're ready here.
All right, is that your client, Ms. Nava?
Yes, Your Honor.
In cause number 2023-0D00319, State of Texas versus David Aguilar. Announcement of counsel, please.
Eliana Elizabeth for the state. State is ready.
Alyssa Nava on behalf of Mr. Aguilar, Your Honor, and we're ready to proceed.
And Mr. Aguilar is appearing remotely from the jail annex. Let me just verify, did we receive I believe we did, yes, the waiver of the in-person proceeding? Yes, Mr. Aguilar, your attorney has submitted, I believe it reflected your signature, your consent to conduct today's plea over this video conferencing format. Is that right?
Yes, Your Honor.
Okay, perfect. Let's go ahead and get started. Sir, in order to get started with your plea, I need to swear you in. Would you raise your right hand, please?
Yes, Your Honor.
Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. You can put your hand down. Would you state your name and date of birth for the record?
My name is David Allen Aguilar. I'm born 5/10/71.
Mr. Aguilar, as I mentioned, I have documents regarding your plea today, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including, the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Aguilar, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, I do, Your Honor.
Did you understand everything contained within that document?
Your Honor, I did.
Okay, Ms. Nava, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
Yes, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, Your Honor.
Mr. Aguilar, are you satisfied with your attorney's representation of you?
More than everything, Your Honor.
Good to hear. Ms. Nava, any reason to believe your client is not presently competent to enter his plea?
No, Your Honor.
Mr. Aguilar, have you ever been found mentally incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
Your Honor.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, Your Honor.
Where were you born?
Here in El Paso, Texas.
Okay. In this case, you're charged with 1 count of fraudulent use or possession of identifying information, number of items between 5 and 10. Sir, to that charge, what is your plea, guilty or not guilty?
Guilty, Your Honor.
Are you making your plea freely and voluntarily?
Yes, Your Honor.
I'll find you're making your plea freely and voluntarily. Ms. Elizalde, would you summarize the evidence, please?
Yes, Judge. Had this case gone to trial, the state would have been able to prove that on or about the 26th day of December 2022, and interior to the presentment of this indictment in the county of El Paso and state of Texas, David Allen Aguilar, hereinafter referred to as defendant, did then and there, with intent to harm or defraud another, possess items of identifying information of another person without the person's consent, to wit, the name and address of Mike Johnson, the name and address of Joyce Young, the name and address of Maria Di Rosario Valdez, the name and address of Raul Chavez, the name and address of Alyssa Malindris, the name and address of Christopher Chavez, the name and address of Veronica Giselle Chavez, the name and address of Priscilla R. Chavez, and the name and address of Noah Cesar Chavez. And
So,
then,
sorry.
Ms. Elizalde, Ms. Wright is indicating something there.
oh,
You go back like 3 names, please.
what's the last one you have? So I'm going to start with number 6, the name and address of Christopher Chavez, the name and address of Veronica Giselle Chavez, the name and address of Priscilla R. Chavez, the name and address of Noah Cesar Chavez, and the number of items possessed was 5 items or more, but less than 10. Your Honor, at this time, we would ask that the court introduce into the record State's Exhibit 1 plea papers and the disclosure forms under 39.14.
Any objection?
No, Your Honor.
So States 1, the disclosures as States 2 are admitted. What is the plea agreement?
Your Honor, the plea agreement is 5 years confinement in the Texas Department of Criminal Justice, probated for 5 years with community supervision throughout the period of probation. The defendant is to be assessed a fine of $500, 100 hours of community service, TAP, mental health caseload, UABA, curfew, restitution on the misdemeanors listed on the plea form. And as a result, the misdemeanors will be dismissed.
Ms. Nava, is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Aguilar, is that your understanding as well?
Yes, Your Honor.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea, bargained, or negotiated case, you do not have an automatic right of appeal. Mr. Aguilar, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, yes, I do.
It was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of fraudulent use or possession of identifying information, 5 to 10 items, and I will sentence you according to the plea agreement to 5 years confinement in the Texas Department of Criminal Justice Institutional Division that will be suspended for a period of 5 years of community supervision. There will be a $500 fine. Ms. Nava, are you appointed?
I'm appointed, Your Honor.
So due to your indigency, I'm going to probate the entirety of the fine, which means you will not owe the fine as long as you are in compliance with your probation, Mr. Aguilar. If at some point you are not in compliance, they can collect the $500. 100 hours of community service, TAP screening, mental health screening, curfew, urine and breath analysis, a total restitution amount of $500 pertaining to the misdemeanor cases. If there are misdemeanor dismissals forthcoming, Mr. Aguilar, the misdemeanor court will sign off on those for you pursuant to this plea agreement. Okay. Is there anything further, Ms. Nava?
No, Your Honor.
Ms. Elizalde?
No, Your Honor.
Thank you very much. Good luck to you, Mr. Aguilar.
Thank you, Your Honor.
Take care.
May I be excused, Your Honor?
You may. Take care.
Thank you.
Who's next?
Judge, do you want to take care of the interpreter?
Yes, Mr. Delgado. Let's take care of Valentin Delgado.
Annex, may we have Valentin Delgado?
Can I ask you one thing, Judge? This is Mr. Stevens.
Sure.
Can you please ask the interpreter to stay for Mr. Ariano?
Okay, so we can, are you on that case as well, or?
I am, Judge, and I forgot to ask for the interpreter.
Oh, okay, sounds good.
Thank you.
That's fine. All right, thank you. Thank you, Mr. Cifuentes.
Yes, ma'am.
Annex, let's get the interpreter function going and then we can have them select the Spanish channel. Also, did we have the waiver on this one as well?
I believe so.
Mr. Munson, while we're waiting for that, I had a quick question on some of these, since we've been seeing so many of these smuggling cases. Are you ever coming across any restitution?
Not, it depends on, usually if there's been a few that had been accidents, that run into a house, those type, then we had restitution, but most of these are traffic stops.
Understood. Okay. Is Annex on the Spanish channel?
Valentin Delgado.
Beautiful. Okay, let's get going.
In cause number 2023-0D0-0344 and 2022-0D0-5197, State of Texas versus Valentin Delgado. Announcement of council.
So hold on a second, because I'm hearing Mr. Cifuentes and I don't usually hear Mr. Cifuentes. Okay,
For 504 visa.
okay. All right. Let's go ahead and start where we left off.
And in cause number 2022-0D05197, State of Texas versus Valentin Delgado. Announcement of council, please.
Preston Munson for the state. State's ready, Your Honor.
Rick Huffman on behalf of Mr. Delgado, we are ready, Your Honor.
And Mr. Delgado is appearing from the jail annex. He is also utilizing the assistance of a court interpreter, Mr. Jesus Cifuentes. I just want to confirm, Mr. Delgado, that you are consenting to conduct your plea hearing today via this video conference, and you are waiving your right to have this happen in person in the courtroom. Is that correct? Okay, then we're going to go ahead and proceed with your plea. I do need to swear you in. If you would raise your right hand, please. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth? You can put your hand down. Please state your name and date of birth for the record.
Valentín Delgado Sánchez. Ok. 13 de diciembre del 92.
And
13
your
de
date of
diciembre
birth?
1992. ¿13 de diciembre de 1992?
Okay, Mr. Delgado, as I mentioned, we are set today for a plea. I have documents reflecting your intention to plead guilty today. The first document I have is marked as State's Exhibit number 1. Those are the papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Delgado, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Sí.
Did you understand everything contained within that document?
Sí, todo.
Mr. Huffman, have you had more than 10 days to prepare a defense in this case?
Yes, I have, Your Honor.
And did you explain the plea papers to your client?
Yes, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, I do, Your Honor.
Mr. Delgado, are you satisfied with your attorney's representation of you?
Sí.
Mr. Huffman, any reason to believe your client is not presently competent to enter his plea?
No, Your Honor.
Mr. Delgado, have you ever been found mentally incompetent by any court? I can't tell if he's talking. Mr. Delgado, have you ever been found mentally incompetent by any court?
No.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, tampoco.
Based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today, sir. Sir, what is your citizenship status?
México.
Mr. Delgado, have you been able to speak with either your attorney, Mr. Huffman, or another attorney regarding the immigration consequences of your plea today?
Sí, ya.
And do you need any more time to discuss those consequences?
No, ya no.
Mr. Huffman, were you able to advise your client regarding the immigration consequences of his plea?
Yes, I was, Your Honor.
And what did you advise?
Well, Your Honor, basically that this plea will result in his deportation, denial of naturalization, and exclusion from the United States.
Mr. Delgado, you've heard what your attorney is advised or has advised you regarding the immigration consequences. You do understand, I'm asking if you understand that there can be any number of negative consequences to your plea today, including the ones mentioned by your attorney. Also, if you were to re-enter, you could be removed, you could be barred from citizenship or any kind of legal status here. The immigration laws also change, so we cannot foresee consequences or negative consequences in the future. Do you understand that?
Sí.
And with that understanding, are you still asking to go forward with your plea today?
Sí.
Okay, in cause number 2023-0D00344, you are charged in count 1 with the second-degree felony of smuggling of persons for a pecuniary benefit. To that charge, sir, what is your plea? Guilty or not guilty? And as to count 2, it is the same charge, second-degree felony, smuggling of persons with for a pecuniary benefit. Again, what is your plea? Guilty or not guilty?
Okay.
Are you making your pleas freely and voluntarily?
Sí.
I will find you are making your pleas freely and voluntarily. Mr. Munson, would you summarize the evidence, please?
This case would have proceeded to trial. The state of Texas were proven beyond a reasonable doubt on or about the 14th day of January 2023 in the county of El Paso, state of Texas. Valentin Delgado did then and there knowingly use a motor vehicle to transport individuals, namely Jorge Luis Guevara Velasquez and Julio Cesar Rodarte Garcia, hereafter styled the complainants, with the intent to conceal the complainants from a peace officer. We have further proven that the offense was committed with the intent to obtain a pecuniary benefit. Move to admit States Exhibit 1, the plea papers, and the 3914.
Any objection?
No, Your Honor.
States 1 and states 2 being the 3914 disclosures are admitted. What is the plea agreement?
Is 5 years TDC probated for 5 years, a fine of $1,250, 300 hours of community service, urinalysis and breath analysis, curfew from 9 p.m. to 6 a.m., no contact with the co-defendant, Christina Lechuga, and all other standard conditions.
Is part of the plea agreement also to dismiss cause number ending 5197, Mr. Munson?
Correct.
Okay. Mr. Huffman, is that your understanding of the plea agreement?
Yes, it is, Your Honor.
And Mr. Delgado, is that your understanding as well?
Sí.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Delgado, do you recall reviewing the trial court certification with your attorney and signing that document?
Sí, sí lo firmé.
It was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. I will find you guilty as to each count of the offense of smuggling of persons for a pecuniary benefit, and I will sentence you according to the plea agreement to 5 years confinement in the Texas Department of Criminal Justice Institutional Division that will be suspended for a period of 5 years of community supervision. There will be a fine of $1,250, but due to your indigency, I will probate that entire fine, which means that as long as you're compliant with your probation, you will not owe the fine. If you are non-compliant, then they can collect the entirety of the fine. There will be 300 hours of community service, urine and breath analysis, curfew, no contact with the co-defendant, Ms. Lechuga. I will also be signing off on a dismissal on cause number 2022-0D05197. Is there anything further, Mr. Munson?
Nothing further from the state.
Mr. Huffman?
Nothing further, Your Honor.
Thank you very much. Good luck to you, Mr. Delgado.
Thank you, Your Honor.
Who's next? Mr. Arellano, I guess?
Yes, Judge.
Mhm.
Annex, may we have Arellano Arturo?
¿De dónde vienes? ¿Tienes domicilio?
Thank you for that dismissal, Ms. Elizalde.
Yes, Your Honor. No problem.
Davidson.
Oh, okay. I don't think he.
And next, do we have, Mr. Arellano?
Yes, it's coming right up.
Yes, thank you, sir.
Así es.
Ready?
Arturo Orellano. Okay.
Thank you.
In cause number 2023-0D0-0447, State of Texas versus Arturo Arellano. Announcement of council, please.
Eliana Elizalde for the state is ready.
Brent Stevens for Mr. Ariano, and we are ready, Your Honor.
Ms. Elizalde, you may have to click on the English channel, please. I don't think I heard you.
I announced ready, Judge. Can you hear me?
I can hear you. Okay. Alrighty. We are scheduled today. Mr. Arellano is appearing from the jail annex. He is also utilizing the assistance of court interpreter, Mr. Jesus Cifuentes. We are set for a bond hearing today. I show his bond being 200,000. I'm not sure if that's split. I have it down just as cash surety. Does that conform with what you have, Mr. Stevens?
Yes, Your Honor.
Okay, you may proceed on your bond hearing.
Thank you, Your Honor. Mr. Ariano is 20 years of age. He is a U.S. citizen, Your Honor. He's lived in the United States since he was 14. If he's released, he will live with his grandparents, and they have an address here in El Paso. He's lived there about off and on for about 4 or 5 years, so he can live there. He went to school at Del Valle. He has an employer, a job available if he's released. He's a painter. I do not believe that Mr. Ariano has any prior criminal history. This is his only case. And he strongly denies that he's done anything to either his ex or his son. This is going to be a case that the state is going to have some problems with, Judge, a lot of problems. This is supposedly happened in November of 2021, and the allegations are sexual assault of the mother of his child and punching the complaining witness in the face and the arm. The photographs of the face were taken, I believe, a day after the alleged assault, and there's no injury whatsoever in the photographs. On her arm, there's possibly a faint bruise on her arm. So there's gonna be problems with that. The assault case, sexual assault case, the complaining witness is claimed that he sexually assaulted her 5 times in a span of 7 days. Bear in mind, they were living together and have a child together. But she stated that the victim told the defendant that she did not want to do it anymore, but the defendant told her that he was not going to stop until he had ejaculated. That was one of the allegations. There's about 5 charges. She's also said that he forced her to perform fellatio. I do not know how he forced her, and also said that she was sexually assaulted without using protection of a condom. The sheriff's office performed a DNA test. The DNA test came back as negative for my client. So there are a lot of problems with the facts of the case by itself, but then his family has been very involved with me, emailing and calling me constantly. His sister sent me photos from May and June of 2022 of the complaining witness, their child, and my client together. There's video of my client with the son. This is not a boy that's being abused. And they're all still together in May and of June of 2022, at least, when this supposedly occurred in November of 2021. And the reason I'm telling you that, Judge, is because the 2 issues that we're dealing with in this hearing are, one, is he a danger to society or to the victims, alleged victims? And in this case, he is not a danger to anyone. Based on what I've seen of the photos and the videos, 7 months after the allegation. And he has no prior criminal history, so he's not a danger to society. He's not a flight risk. He's a U.S. citizen, went to school here, is employed here, has family here. So based on all of that, Judge, I'm asking the court to reduce his bond substantially. I know you cannot give a straight PR bond on a case with this allegation, but I'm hoping that you'll consider a split bond with a really low surety bond, maybe $10,000. I think that would be fair under the circumstances.
Thank you, Mr. Stevens. Ms. Elizalde?
Judge, I would disagree with Mr. Stevens' characterization of my case. He is correct, though, that he does not have criminal record. Based on the facts, this is what I have. Officers were dispatched in reference to a domestic assault on the 13th. It is in fact correct that this victim number 1, which is his ex and the defendant, have a child together. On November 3rd or 4th was the first sexual assault. On November 6th, the victim received a message from another male. This made the defendant upset, and he punched her on her left tricep area. That was November 6th. The defendant then grabbed CW by the hair and yanked her to the ground. On November 8th, the CW and defendant were having sexual intercourse, and she told him to stop because he was hurting her. The defendant grabbed her by the arms and told her, "You're not going anywhere." Defendant stated he was not going to stop until he finished and that she was his. The last sexual assault occurred on November 11th. And then on November 13th, the CW confronted the defendant about leaving the child alone in the bed and tries to break up with him. The defendant says, "You think I'm going to let you go?" He locked the door from the inside, stood in front of the door. The victim told him, "Please, if you let me go peacefully, I won't call the cops." The defendant stated, "You're not leaving me, you're not going to work." Defendant then kicked her leg. Defendant grabbed her by the hair, yanked her to the ground. She stood up and grabbed her child. The defendant then punched her in the face. The victim stated after the punch, she felt dizzy and had a blind spot. Defendant then punched the child. Now it's unclear if he was attempting to punch the child or if he accidentally hit the child while he was trying to hit the victim. And both the victim and the child were taken to the hospital. So this is what I want to say. As to the arm, it happened on November 6th. So it's not a problem that it's faded because we are talking about a reporting date of November 13th. And then as to a punch to the face, it happened November 13th. And yes, Mr. Stevens, sometimes it takes some time for bruises or any of that to show up.
But let me just ask, because what I want to be clear is, because it is, the incidents are what, about a year and a half out. We're talking the end of 2021. Did she immediately report it when she left? Is that, because I did see a reference to 2022 on some testing, but she had reported it immediately after. Is that what happened?
Immediately after the last incident, Your Honor.
Okay, got it. All right.
Judge, the photos of her face were taken a day after. I think it was a day after the alleged punch to the face, and there's nothing on her face.
And like I said, injuries don't always show up, but the last thing I do want to mention, Judge, is there's a report, and opposing counsel says his DNA wasn't found, but there was in one of the reports, because there's two, semen detected. So what I will say, Judge, is we believe he's a danger to her. We would oppose bond modification given the nature and circumstances of the crime alleged.
And if he was a danger to her,
Mr.
Judge, then
Stevens,
why
just a
were they
second.
still together?
Hold
in
on,
May?
Mr. Stevens, please don't interrupt. She didn't
Yes,
interrupt
sir.
you, so let her finish and then I'll let you respond. Go ahead,
Okay.
Ms. Elizalde.
Judge, we have had contact recently, and the last thing I'll mention, and then I'll hand it over to Mr. Stevens, is there was some concern that he was contacting her via social media, though I just saw that today and need to follow up because I'm not sure how he would be doing that from jail, though it is possible as they get tablets and so and so. But in any event, we do believe that this defendant is a danger to her, and the nature and circumstances of the crime are extremely concerning.
Okay, now Mr. Stevens, go ahead.
I agree. The nature of the allegations are concerning. The facts are not concerning. When somebody's punched in the face, there's going to be something there. And the fact that she was still hanging out with him in May and June of 2022, and they're having a good time. How does that show have any indication that she's afraid of him or that he's any kind of danger? And so that's what I've got. That's all I've got today, Judge. I really am strongly urging the court to reduce this bond.
So let me ask a little bit. I know we're early on in the case, but okay, so at the time of the alleged incidents, they were living together. After that, what was the living situation? Did they continue to live together? Or were they separated? What was the situation?
The information I have, Judge, is from Vanessa Ariano, and she stated that on May 17th, 2022, the complaining witness, I won't list her name on the internet, created a family group where Arturo, my client, Arturo, the grandfather, and a sister, a stepsister, a stepmother are all in this chat group. And she was sending out photos of them. They lived for about 2 weeks in the house of Arturo Ariano's father. And then they went to live in the house of Arturo's mother, Mrs. Myra Diaz, for about 2 months. So I have not been able to confirm any of that. That's what I was told by a family member, Judge. So that's the information I have.
Ms. Elizalde, is that consistent with information you have? They continue to live together?
I do not have that information, Judge. We've established recent contact, but that wasn't outright asked. What I will tell the court is that the victim did ask for an emergency protective order and stated she feared for her life. So I don't have anything to indicate that they remain living together afterwards.
Do you know your client's address, Mr. Stevens? I am looking at the protective order, which is due to expire on April 1st. And it does have a 79938 residence, a place of employment. Do you know where your client was living last?
Do you want me to give it to you right now?
If you can tell me at least the street name.
It's Nottingham,
Okay.
79907.
Okay. So the protective order, which is on file here in this case, it was a JMAC emergency protective order, does list a different address. Okay, anything else?
The only thing I would add, Judge, is my client's in agreement with staying completely away from the complaining witness. And as for his son, I would ask that he be allowed to see his son if there's an appropriate court order in place allowing it. So if that way, he would have to go to court and get an order allowing visitation. And I would also instruct Mr. Ariano to have no contact with the complaining witness through social media, telephone, or any other means, either directly or through a family member.
Okay, so with respect to the bond, I am going to reduce the bond. I'm not going to go to that number that you've mentioned, Mr. Stevens. I'm going to reduce it to 200. I'm sorry, reduce it to 100,000, and that is going to be split 50,000 cash surety, $50,000 PR. Is going to include those conditions you just mentioned, which, well, it's going to be a couple of things. So he's going to report once a month to the PR bond office, can use no illegal substances, subject to testing, curfew from 9 a.m. to 9 p.m. to 6 a.m., commit no new offenses. Most importantly, he is to have no contact with the complainant in this case. I'm going to make, as a condition of his PR bond, all of the conditions that are listed in the protective order. So even after the expiration, Mr. Stevens, basically the PR bond conditions will be an extension of that protective order in a sense, in terms of the conditions. Those will be part of the PR bond conditions. That includes not going within 200 yards of the residence that is listed in the protective order, the place of employment listed in the protective order, also to include the complainant and the, what I think is the child here, or his child care facility. So I'm going to keep that in place for now. That will be a condition of his bond. Is there anything else in terms of conditions, Ms. Elizalde, that are not included here?
Judge, I think you have them all.
So if it's possible, Ms. Nieto, I would like to attach the protective order to the bond order, just so we're clear as to what the conditions are. Yeah, 50-50 split. That's what we're gonna do. All right. And if there's nothing further, then we're adjourned on this matter.
Thank you very much, Judge.
Take care. Oh, also, oh, never mind. That's fine. Thank you, Mr. Arellano. Anyone else needing the interpreter?
Not to my knowledge, Judge.
Mr. Cifuentes, run.
I'm working on it.
Thank you for your assistance today.
Yes, ma'am. Ya hemos terminado, señor. Muchas gracias. Ya puede seguir las órdenes del personal de la cárcel.
All right, who's next?
Staying on page 22, annex, may we have Jose Avila?
Ms. Warwick, are you there?
I am, Your Honor. I apologize. I'm having a little bit of technical difficulty, but I am here.
Okay, go ahead.
Cause number 2018-0D04860, State of Texas versus Jose Avila. Announcement of counsel, please.
Eliana Elizalde for the state. State is ready.
Melissa Warwick for Mr. Avila, Your Honor, and we are ready as well.
Mr. Avila is appearing from the jail annex. We're set for a pre-revocation hearing. I feel like we were here not too long ago. Let me see.
Your Honor, we had a bond hearing in February. Judge Reyes presided over that. The reason why I asked for this hearing to be set today is at that time, Judge Reyes had ordered the probation department to do an evaluation on my client in the jail. And as of last week, when I spoke to Mr. Avila, no one had been to see him, and it's been over a month. So I was hoping we could address that with the court today. And also if ADA Elizalde could make a recommendation. I know that she did file the motion, I believe, but I don't believe we have a recommendation as to the motion to adjudicate.
I'm just looking at the report, Carla, if you're there, it looks like yesterday, did the assessment happen yesterday?
Yes, Your Honor.
Okay. Okay.
The top assessment, if I may judge,
Mm-hmm.
the recommendation was intensive outpatient. And if released, Mr. Avila would be referred to attend intensive outpatient through Ozark.
Had we discussed anything? I'm going actually backwards on this report. Had we ever discussed anything about what we were going to do with Mr. Avila?
No, Your Honor. We were waiting for the state one to file the motion, which they did after the hearing last month, and then for him to have the TAP assessment. So we've never actually had a discussion with Your Honor about it.
Has he received any treatment in the past?
Are you asking me or the probation department, Judge?
Whoever knows.
He has, Your Honor. I believe he did BHRTC, if I remember correctly, and he successfully completed it.
Well, when was that? Can't be that successful if we're right back where we are.
At that time, Judge, let me rephrase. At that time, he had successfully completed it. Your Honor, I apologize. I'm just going through my notes. And perhaps Ms. Pineda could correct me if I'm wrong on that.
Yes, Your Honor, he was, this was back on 2020, January 2020. I know there was an email that was sent to you, Judge, by the officer, Ms. Dominguez. I was just trying to find it to see if I can forward it to you. That email was back in December of 2022, basically letting you know, informing the court of non-compliance. Unfortunately, Mr. Avila does struggle with substance abuse, and he wasn't attending his EHN appointments at the time. And you ordered, Your Honor requested a bench warrant that was issued.
So how many times has he gone to BHRTC?
I believe it was just once, Your Honor. Let me see. He went through BHRTC, and then he's been really, he continues, like I mentioned, he continues with substance abuse issues. He, from there, is referred to different, I know at one point he went to Trinity for detox at Aliviane. They, you know, at the same time, it doesn't, he has EHN as well, but he misses appointments, so he can't, with substance abuse and not complying with medication, it's not working for him.
Have we ever seen a period of, I guess, what's the longest period of time he's been compliant?
Well,
I'm really not at it. I'm not at any more treatment, Miss Work. I mean, that's where I'm feeling I am right now. I'm kind of at 2 TDC and.
Understood, Judge.
Well, I don't know if I'm at 2 TDC. I need to take that back. I'm at TDC. Miss Elizalde, why don't you chime in here?
Judge, yes, Ms. Work, I hadn't put up a rec because I wanted to know what the TAP assessment revealed before I did that.
Okay.
I do not agree with outpatient based on, I'm not sure how we get to outpatient considering he's missing appointments, nor do I think BHRTC would be appropriate. I was thinking either revocation or maybe safe P. That's the two routes that I was thinking if the court was considering.
Would the court consider safe P, Your Honor?
That's all that's left, really.
Right.
That's all that's left unless we're doing time.
Would the court consider either option and give me time to discuss it with Mr.
Yes.
Avila?
Yeah, I'll give you 30 days. If say, okay. I'm trying to go through a few things and looking at his history was what I was starting to do. Carla, are you able to tell even outside of this case if he's ever done safety? Does he have any pen trips?
I don't think so, Judge.
Okay.
Judge, and while we look, I sent you the email that was sent to the court.
I found those. Those were from Betsy Dominguez, right?
Yes, Your Honor.
Yeah, I found those.
Let me see.
Back in 99, we're already talking there. Drugs, inhalants, ag assault 2001. Received probation in 2005. I don't see any kind of revo there. I mean, that's.
Yeah, probation.
Hmm?
I mean, he's been revoked on probation from unlawful possession. I don't see any pen trips, Judge.
Released to us, WBTC, that's BHRTC, right? Yeah, that was in 2020. What was your time rec, Ms. Elizalde?
I was thinking 3 TDC.
Okay, there are the options, Ms. Swark, 3 TDC or SafeP.
Okay, thank you for clarifying, Judge, because Ms. Elizalde cut out a little bit on the TDC time.
I heard that. I mean, was I right on that, Ms. Elizalde?
3, Judge, yes.
3, okay, I got it. Your Honor, if I would just ask for that reset for 30 days so I can speak to Mr. Avila and he can consider those 2 options.
You got it. And I also, I think I do remember seeing this on YouTube. If there are any other concerns, please let us know at the next hearing. We'll reset for 30 days.
I will, Your Honor. I appreciate that. Thank you very much. May I be excused?
You may.
Thank you, Judge. Have a great evening.
Mr. Avila, you too. Who's next?
Middle of page 23, Judge.
Mhm.
Annex, but we have Donovan Pace.
Oh,
This is our last trial. Well, no, I guess we have Mr. Barra still. And Mr. Huffman. Mr. Huffman, are you meeting with your client from this morning?
Sorry, just did meet with him and we looked up the case law. And yeah, I need to speak to Ms. Elizalde.
So if you got your continuance filed?
Well, I'm most likely gonna file it, Judge, and there's, I don't have the best issue, Judge. My clients.
I don't need all the details. I just need to know if you're still on the hook for trial. So if there's no agreement on a plea for Thursday, I need your motion for continuance, okay?
Are we still at 6 months, Ms. Elizalde?
yes, we are.
Okay.
Thank you. Okay, thank you, Carla. All right, I think we have Mr. Pace. Do we need Mr. Ortiz's office, please?
Mr. Ortiz, are you there? He was there a minute ago, Judge.
Mr. Ortiz, are you there?
Hi, Judge. Sorry about that.
No worries. All right. Calling cause number 2022-0D01342, State of Texas versus Donovan Dreon Pace. May I have announcements, please?
Eliana Elizalde for the state is ready.
And Ruben Ortiz on behalf of Mr. Pace.
We are scheduled, oh, I'm sorry, Mr. Pace is appearing remotely from the jail annex. We are scheduled for both the final hearing plea deadline and a bond hearing. Let me just get the rec for Ms. Elizalde, please.
Judge, I do have a new recommendation. It's a misdemeanor assault bodily injury, 6 months.
And I think my client should have credit, Your Honor, for that already. If we give him, what I'm saying, Judge, if we could give him credit for the federal, remember he spent a lot of, like 8 months in federal custody, Judge?
Do we have that information, Mr. Ortiz?
I can get it from his federal lawyer, who was Ms. Dillinger. Ms. Dillinger represented him in the federal New Mexico case.
How quickly do you think, yeah, because I only have him here 25 days.
Yeah.
How quickly do you think you can get that information?
I could, you know what, she's really, really kind when I request stuff. If I can call Ms. Dillinger, I'm pretty sure all we need is the judgment. All you need is, what do you need, Judge? The judgment and.
I just want something that reflects the actual time that he was there and the
Okay.
dates.
Let me call Ms. Dillinger, Judge. If we come back next week, Judge.
That's exactly what I'm thinking. I'm thinking of resetting you from 1 week at 3 p.m. I'll have it again, just everything reset, the final hearing, plea deadline, and the bond hearing. But if you have that information and will provide it to the court coordinator, we can anticipate that being a plea. So what it means, Ms. Elizalde, I would just send over those plea papers now so we can get them taken care of. Are you good with that date, Mr. Ortiz?
What date is it, Judge? I'm sorry.
Perdón, let's see, we're the 21st, so I think it's the 28th. It'll be the 28th, a week from today at the jail docket.
It's next Tuesday. Okay. What time, Judge?
At 3. I was gonna say we can bring you in on Thursday, but that really puts you kind of in a crunch to get that information from Ms. Dillinger.
What do you think? You think I can make it at 3? Yeah.
Just to notify the.
I have, geez, that contested rebel, huh?
Just to notify the court, while he figures that out, victim will be making an impact statement, whether it's in person or Zoom.
We can do the morning on Tuesday at 11 a.m. I'll have to bring him over, but I can do that.
I'm gonna have to move the Elijah Hill.
You know, who?
Yeah,
I think I could do it. No, I think I could do it at 11.
Okay, let's do the 11 a.m. in person on Tuesday.
Okay, Judge.
So the 28th at 11 a.m. Again, it'll be scheduled, so we'll arrange for transport of Mr. Pace. Okay.
Okay, Judge, let's do that. Yeah, that's great. And then I guess hopefully I can have all the information already, and I can send it over to the court and also to Ms. Elizalde.
Yes.
Also, Judge, there's an issue with the bond hearing also, regarding some new allegations.
For Mr. Pace?
Pardon me?
On Mr. Pace?
I think so, Judge. I think he's got a new case that occurred while he was in jail, and he's being accused of something while he was in jail.
Oh, I do have a notation here. I have misdemeanor drug arrests in February. That's all. That's what my little notes say.
There's some allegations that occurred while he's in jail, in prison, I'm sorry, in September.
Mm.
When you
I'm
send
not representing him on that.
I'll look at it and then just send me the paperwork of when he was in jail. I'll match it up.
Okay. Yes, ma'am.
All right. We'll see you on Tuesday. Mr. Pace, your attorney's
Thank you so
working on
much.
a few things. We'll bring you back in 1 week, okay?
Thank you,
All
Judge.
right. Thank you, Mr. Ortiz. Bye-bye.
Thank you.
Who's next?
Top of page 23, Judge.
Mhm.
And next, may we have Alfredo Ortiz?
They're coming right up. No, it's still a lot there. Where? Alfredo's a lot there.
Miss Becky, on this one, on Alfredo Ortiz, 0977, we need to get his trial track going with, looks like he has, oh no, that one was dismissed. So if we can just get him scheduled on the next regular setting, we need to go ahead and give him all that, because I don't think we have anything done yet.
Okay.
Maybe it's a new case activation. Yes. Mr. Huffman, are you on Alfredo Ortiz's case? Or who has it?
No, Your Honor, I have Alex Rodriguez, Judge.
So public defender is on Alfredo Ortiz,
Your
cause
Honor,
number 2023-0D00977.
Oh,
Yes, we already know, I already know the big O, I think, on this one. Ms. Elizalde.
I think it's Brent. I think Brent has this defendant, Mr.
Oh.
Stevens.
So maybe you need to let Mr. Stevens know to log back on.
Judge, can I get the cause number one more time? I'm sorry.
2023-0D00977.
All right. He's right down the hall. Let me go grab him, Judge.
Okay, maybe we can go to the next one if anybody's ready.
Is Mr.
Oh, it's public.
Solomon?
It's Mr. Huffman's as well. Okay.
Yes, Judge.
Oh, and he is booked on it. Okay. Okay, wait a minute.
Now I'm wondering what what the O was, what.
Mr. Ortiz is booked on a murder.
Oh. How did I?
Yes.
Mr. Huffman, I think you have the only other case remaining. So Annex, if we could have Alex Rodriguez, and then we'll come back to Mr. Stevens' case.
Yes, Your Honor.
Thank you. You may want to let the unit know, Ms. Elizalde, on your end also, if that's going to change things.
Yes, Judge. And just, it's here, it's in this jurisdiction?
So I think because we have the drug case, we will probably get it.
Okay, yeah.
It's not indicted yet, but he is booked on it. Alleged date of offense, I believe, is July 15th of 2021.
I'll send an email to Mr. Arango and Roa.
If you need a PD case number, oh, I thought I had it. I don't. I have a JMAG 23.
Okay.
-03347. Oh yeah, I do have a PD case number is 21-235169. All right, let's take care of Mr. Rodriguez.
In cause number 2017-0D03494, State of Texas versus Alex Rodriguez. Announcement of council, please.
Eliana Elizalde for the state is ready.
Rick Huffman on behalf of Mr. Rodriguez, we are ready.
Monica Lerma, adult probation.
All right, I was just going through the previous summaries. This is one of those review cases. Where did we leave off last time, Ms. Lerma?
Your Honor, I believe you had just appointed Mr. Huffman to Mr. Rodriguez's case, and we are back 1 week later. But I had let you know about his Mr. Rodriguez's lack of SOTP attendance, compliance, and that there is a chance that he can possibly
catch up,
but pretty quick, yes, if he really put some serious dedication into it.
All right, Mr. Huffman, what's that face? Do we have some understanding? Let me see what's going on.
Well, I did speak to Mr. Rodriguez, Your Honor, and he's been in jail for 6 weeks, and this is the first basically admonishment from the court since he's been on probation for about, I guess, 4.5 years. And just, I guess, a little background, Your Honor. Mr. Rodriguez has a 2-year-old son who he lives with, along with his wife and his mother, and that's very recent, Judge. And he's basically been pretty upfront with registering, with keeping in contact with the probation department. There were some admitted, I guess, problems with the treatment, but Mr. Rodriguez has assured me that this is his #1 priority. I don't, I don't want to put it on Ms. Reyes. It kind of seemed to me like Mr. Rodriguez was kind of comfortable with Ms. Reyes and kind of had a little bit of an understanding. Ms. Reyes was his older probation officer, and I think Ms. Reyes has since left the office, and Ms. Lerma is the new probation officer. But he understands where he's lacking, Judge, and he wants to fix that as soon as possible. He does have a CDL, Your Honor, and the probation department knows that as well, Judge. So he's got a good job. He wants to get back to work and, you know, do the things that he needs to do on probation. I think he's pretty, sure of what what he needs to do, Your Honor. And I think the 6 weeks that he's had to think about it, was enough time, Your Honor. And we're hoping that the court would consider giving him, one more chance here.
All right, anything else, Ms. Lerma?
No, Your Honor, again, we would let the court know that if he continues on probation with it, which is our recommendation, that he needs to be modified in order to have supervised contact with that child, as it was never done before.
Ms. Elizalde, thank you, Ms. Lerma. Ms. Elizalde, anything else?
I would object to that modification until he catches up with treatment.
Okay. Anything else?
Judge, just in response, I think the only other option, Your Honor, that Mr. Rodriguez could basically live would be in his boss's semi-truck. That's where he was for about 3 months or so before, his mom and wife had found this house. He's had issues finding places to live, Judge, due to his registering situation. But it is his biological son. He's 2 years old. The allegations, Your Honor, the allegations that he has pled guilty to, that he's on probation for, involve, I think it's like a 15-year-old or 16-year-old female. I don't know if that makes any difference, but we would ask the court to consider that modification and let him live with his 2-year-old biological son.
Okay. So he pled in 2018, he's got 10 years, so 2028. The motion has been filed. What I am willing to do is, because the treatment provider has indicated that there is a potential to get on track here. That is the only reason I am going to propose this. We leave the motion pending. I agree to release him to be compliant with all conditions of his probation, which of course include the treatment. What's listed here, Ms. Lerma, is about 6 months. I guess I know that's kind of hard to determine. Basically, I would want to do a probation review in 7 months to see if he has completed and been able to move on. Obviously, in the interim, if he's not compliant, I need to know from probation right away.
Yes,
if it's complicated, we can certainly have a hearing, but if we're seeing the same kind of behavior, we just go on the motion and we just revoke his probation. I am not going to modify his probation in any way to include that contact with the minor child until he has compliance. I agree. He has not been diligent over the course of probation. And to be quite honest, Mr. Rodriguez, you're receiving a huge benefit. Literally, your probation should be revoked and you should go to prison, period. So although this might present some difficulties, to include financial difficulties, that's why you should have been compliant in the first place. So it is a window. It's not a huge window, but I know it's going to seem long to your client, Mr. Huffman, where he can get on track and show the court that he actually warrants or merits being on probation and doing what he's supposed to have been doing in the first place. So that's where I am. If your client is good to go with that, happy to execute that now. If there are any other issues, I can reset you for a week. But if you're good to go with that, then this court is certainly good to go with that. Ms. Lerma, you're his probation officer at this point?
I am tending to the case, Your Honor, interim. Yes.
Okay. All right. Mr. Huffman?
Yeah, Your Honor, we are more than good with that. We're grateful for this opportunity. We just asked the court possibly consider giving us a hearing maybe in 3 months rather than 6 months, so we can revisit that modification. He misses his kid, Judge. maybe we come back in 3 months rather than the 6 months that's already.
I'll rely on probation to let me know if, say, in 3 months, Ms. Lerma, he's wholly compliant and we still have an urgent need at that point to make a request. Happy to have a hearing at that time. I'm not going to schedule it now. So
Understood.
7 months out, I want to know if he's been compliant and if we have any issues, other issues. I think that was the only modification that was being requested. So we're going to go with that. We'll go ahead and release Mr. Rodriguez.
And Your Honor, if I may, Mr. Rodriguez, obviously let the sheriff's department know where you're living, obviously, and the probation department, and give me a call as well, just so we can.
And Your Honor, he can report to me as soon as he is released. If it's a weekday, if it's this week, he can report to me.
Okay.
He knows my phone number. He can call me as soon
There
as
you
he
go.
gets it.
There you go, Mr. Rodriguez. You have your attorney and your probation officer ready to assist you if you have any questions. All right, then I don't think there's any future settings. We'll be good to go. The only one, of course, being the one, the 7 months out. Okay?
Thank you. May I be excused, Your Honor?
Thank you, Ms. Lerma. Thank you, Mr. Huffman.
Thank you, Your Honor. And Judge, on a different case, I'm gonna file that motion. Did the court want us to come on Thursday?
If you're filing a motion for continuance and there's no agreement with the new rec, then I don't need you to be here on Thursday.
Is the court inclined to grant the motion, Judge?
Yes? If it's unopposed and we don't have an agreement, sure.
I think this is gonna be one we're gonna work out. There's just, we need a couple months, Judge. It's a long story, but,
File your motion.
yes, Judge.
All right. May I have Alfredo Ortiz, please? That's all you have, right, Mr. Huffman?
That's it. Thank you,
All right.
Judge.
Watch, I wrote Brent Stevens on this and it's not him.
Mr. Stevens, are you there?
I am here, Judge. Thank you.
Is Alfredo Ortiz your client?
He most certainly is, Judge, and I apologize for not seeing him on my calendar. Judge, we have a problem,
I know.
a big problem.
What? What now?
On the 15th, my client was booked in on a murder charge,
I'm aware of that.
and we haven't been appointed, or at least I don't have an open case for it. Can I please have a reset for 2 weeks?
Okay, let's go over here. So let me, yeah, I saw it on the booking. Obviously, it hasn't been indicted. Yeah, you can have a reset for 2 weeks. So we'll reset this one for April 4th. At 3 p.m.
That looks like a good day for me, Judge.
All right, bond hearing April 4th at 3 p.m.
Your Honor, Alfredo, I will come and see you at the jail, okay? Thank you.
Thank you, sir. Thank you.
All right,